Sorry.
Hearing in detail, Sagicor Bank, Jamaica Limited and Taylor-Wright.
Yes. Mrs. Phillips, I understand you're happy to be referred to as Mrs.
Quite happy with that.
Oh, well, we're very happy to call you Mrs. Minute Phillips. However, let's proceed.
May it please the Lords. Arise on the matter of JCPC 11 of 2017 on appeal from the Court of Appeal of Jamaica. My name is Sandra Minot Phillips, and I appear for the appellant, Sagicor Bank, Jamaica. Learned friend Litro Hickson appears with me, and we are instructed by Myers, Fletcher and Gordon.
Thank you very much indeed. But can I make it clear from the outset that we have read all the papers, particularly the cases for both sides, and we're quite satisfied that this case should not occupy the time that has been indented for. We would therefore greatly appreciate economy of presentation.
Very well, my lords.
Thank you.
That's just for politeness. I wish to say that my friends David Alexander QC appears for the respondent.
Yes.
And Evelyn Taylor-Wright. With him, my friends Anwar Wright and Owen Roach. They're instructed by Taylor-Wright and Company. As your lordships are aware, the Court of Appeal found that the Honorable Mr. Justice Sykes was palpably wrong in awarding summary judgment to the appellant bank on its claim against Mrs. Taylor-Wright to recover an overdue and unpaid balance on the demand loan facility it gave her. It is a bank submission that the Court of Appeal erred in so finding and in substituting its decision for hers. The decision of that court was to set aside the award of summary judgment to the bank and to remit the matter for trial by a different judge. The bank now seeks to reinstate the summary judgment awarded in its favor.
Yes, well, we're aware of all of that. I mean, basically, your case is that the bank's case has in effect been either admitted or accepted by the respondent in this case. And on that basis, the proper disposal was that chosen by the trial judge.
Yes, my lord, that is the bank's case.
Yeah.
And your lordships will no doubt be aware that there are several facts not in issue, and which essentially the bank is submitting.
Yes.
Dispose of there being any factual issue for trial. And what remains then is essentially whether there's a legal issue which should go to trial. So I think it would be most economical, my lords, if I take you to the Court of Appeal's reasons for finding the learned judge below palpably wrong.
Yes.
Perhaps that might be the most economical way of dealing with it, my lord.
Yes.
And I first would like to take you, my lords, to MS 48, paragraph 52. And I'm here referring to the judgment of the Court of Appeal.
Yes.
One of the reasons that court found the judge below to be palpably wrong is that he said that under Section 30 of the Act, they refer to the presumption that where a party's signature appears on a promissory note, that party is prima facie deemed to have become a party thereto of value. And then the court went on to say that in order to rely on that presumption, the holder of that promissory note must prove that the note itself is valid and was validly negotiated. Bank submits that this is a wrong interpretation of the statute, and it disregards Evelyn Taylor-Wright's receipt of value subsequent to the alleged forgery. The next reason that the Court of Appeal gave for finding the judge below palpably wrong is found at MS 49, paragraph 54,
Yes.
where the Court of Appeal criticized the judge below for not appreciating the importance of Marvelyn Taylor-Wright's allegation that the promissory note annexed to the bank by the bank to its statement of case was a forgery in light of Section 24 of the Bills of Exchange Act, which provides that a promissory note may be defeated by a forged signature or an unauthorized signature. That is, of course, my lords, unless she is precluded from setting up warrant of authority, which the bank submits is the case here.
Yes.
The other reason why the Court of Appeal found the judge below to be palpably wrong, you will find at MS 52, paragraph 58. And you will see in the first 4 lines of paragraph 58 that the Court of Appeal says, these varying accounts as to whether the signature on the 27 July promissory note was that of the appellant raised issues which may impact the respondent's prospects of success on the claim, since the appellant could not be held liable on a promissory note that may contain her forged signature. And it is submitted by the bank that this too is wrong. If receipt of value is not an issue, or if she is precluded from asserting warrant of authority. And then, towards the end of that paragraph, you will see the following dicta from the Court of Appeal, starting in all the circumstances.
Yes.
In all the circumstances, it is my view that there are indeed tribal issues as to whether the appellant's signature on the July 27 promissory note was forged, and she therefore had no obligation to pay under it, and or whether she was precluded from setting up the forgery or warrant of authority, or had ratified the alleged unauthorized signature. The learned judge therefore erred when he found that it was not his function to make such an assessment.
Well, essentially, your argument is that a discussion about whether or not her signature was forged is extraneous to the main issue in the case.
That is correct, because once there is receipt of value, and it's receipt of value subsequent to the alleged forgery, then the bank's position as a holder is, for value, is unassailable.
Right.
But you don't have to set yourself up as the holder for value of a negotiable instrument, do you? Why should you? Your case is that you lent her money and she hasn't paid it. She says you lent her money and she hasn't paid it.
That is correct, and that is the basis on which the judge at first instance proceeded.
Yes, but can I ask you a prior question, if I may? To what extent, if at all, could the bank ever negotiate this promissory note? Because it was in support of a loan where the principal sum would be diminishing as repayments were made towards the capital, as happened. So the promissory note is for a sum certain in money, and it's asserted that it's the equivalent of cash. But could you ever negotiate it to anyone else when it in fact is covering a loan which is being diminished over time? Does the bank negotiate these promissory notes?
No, it wouldn't be negotiated in that sense, my lord. It is just merely, it allows the bank the right, it gives the bank the right to sue on it. And so the bank would be using it really as evidence of the borrower.
Yes, but it would be using it as evidence because ultimately the bank couldn't sue for the principal sum if the principal sum had been reduced.
No, and the bank, in fact, only sought to recover, and only, in fact, recovered
Yes.
the balance, the unpaid balance that was due.
And pleaded at MS 99 that it was doing it under a demand for a particular loan number, and also pleaded that it was that the sum it was suing for was by reference to the letter of 23rd March 2010. So this wasn't just an action for the recovery under a promissory note.
That is correct. That is correct. That's the bank's position.
If there hadn't been the document which appears at page 103, if it had never existed at all, would you or would you not have been entitled to recover the money?
And the answer to that is yes.
Does she disagree with that?
She apparently does.
Well, I don't know that she does. She's pleaded that she lent it to her and that she hasn't repaid it.
Well, as I understand her case, and I'm sure her counsel understands it better than I do, but as I understand her case, what she's saying is that the bank's action is confined to the particular promissory note at page 103.
Yeah.
That's right.
And in fact, the bank's position is that she ran the risk of the court being of the view that the claim was wider than that. And the court was of the view that the claim was wider than that it was an action on a contract.
Well, I think a better way of putting it is that the bank's claim was not dependent upon that. That's the purport of my Lord's question.
It was not, yes, it was not dependent on that.
Certainly not once she herself pleaded facts which, on the face of it at least, entitle you to the relief that you're seeking.
So the reason why actually the whole argument in relation to the bills of exchange and the promissory notes came in at all really was because of ground 4 of her appeal before the Court of Appeal, where they were contending that the judge erred in granting summary judgment in favor of the bank because he failed to appreciate the significance of the Bills of Exchange Act and sections 23, 24, and 30, etc., of the Bills of Exchange Act. And that is why it segued into a discussion in relation to the Bills of Exchange Act.
If hypothetically it had been possible to sell this promissory note to somebody else, for the bank to sell it to somebody else, and you've already said that it doesn't seem very likely, but just supposing, and if the somebody else sued the defendant for the money, relying on the promissory note, then would it be a defence that the thing was forged?
No, it would not be.
Really? Why ever not?
Because because the allegation that it was forged goes to, as it were, shift the burden of proof in relation to the issue of receipt of value.
Oh, I see. Well,
and that's really the relevance of the allegation of so once subsequent receipt of value is established, then forgeries of limited use to anyone. In fact, it's a red herring, somewhat of a red herring.
okay.
So in this case, there is no issue about subsequent receipt of value. That's admitted.
No, quite. But I think you might want to say in any event that simply because someone who was perhaps foolish enough to acquire the promissory note, if it be the fact that that person could not sue on the promissory note, doesn't destroy the fundamental essence of your case.
It doesn't destroy. If it was a fact that they couldn't sue on it, it wouldn't destroy the essence.
Yeah. Well, do we need to say very much else?
Can I just check with you one point which is raised against you, which is the difference between the judgment sum and the amount claimed in the particulars of claim? My little pocket calculator buried in my mobile phone tells me that the difference is really just attributable to the accruing interest at the daily rate stated in the particulars of claim, plus the fees. And I assume you say the fees are recoverable because of the terms of the commitment letter.
Well, except to say, my lord, that at the time that the summary judgment application was filed, there was more than one claim. So there was a claim in relation to demand loan number X.
Leaving those aside.
And there was also the claim in relation to the credit card.
Yes.
So, but subsequently, the debt in relation to the credit card was settled.
Yes.
So at the time when the summary judgment and that was subsequent to the filing of the application for summary judgment, because if you look at the affidavit in support of the application for summary judgment, you will see references to
Yes.
the credit card debt.
Yes.
But then that debt was settled. So when the application for summary judgment came on for hearing,
Well, they then limited it to the debt due under the original loan, and
They then
with the interest accrual
Yes.
simply stated as a figure.
yes.
But I think if you work out the difference between the interest claimed there and the interest originally claimed under the loan, it's just the accrual at the stated daily rate between the two dates.
Yes, my lord. And I personally did not detect an error in the bank's calculation.
No, I didn't either.
I didn't detect an error in the bank's calculation.
I mean, there might be an issue about whether it's one lot of days or another lot of days, but it's only a day apart, and no point was taken about the number of days as far
It
as...
was a 360-day cycle, and when I did the maths, I in fact came up with the 11,000 whatever, and it was a simple interest figure.
Yeah. Thank you.
Thank you. Mr. Hickson? No, not one. Mr. Alexander?
What's Milady? I was going to deal with both bills of exchange and what I call the pleading points. Having observed the discussion this morning, I suspect I would not be happily received if I was to talk about
Don't feel in any way curtailed.
My Lord, having heard the way the discussion has gone as to whether essentially the key issue in this case goes, I think probably the best thing to do is if I start with the civil procedure rules point.
Yes, absolutely.
Run through that as quickly as I can.
But don't feel under any constraint of time. I mean, the observation that I made at the beginning of the case is not meant to put pressure on anyone, but it's just that looking at it and having read the very helpful cases, we did think that the issues could probably be presented reasonably speedily.
No, I don't disagree with that.
Yeah, good.
I'll do my best to present them as speedily
I'm sure you will do extremely well.
My Lord, as I say, the civil procedure rules, the Jamaican civil procedure rules, or the CPR points, are dealt with at paragraphs 14 to 17 of the bank's written case, and they correspond with grounds 1 to 3 of the bank's grounds of appeal. Now, my Lord, just before I come to the position that the Court of Appeal took in relation to what the particulars of claim, the ambit of the particulars of claim were, I think I should very briefly just take you to the relevant civil procedure rules. There are only, I think, 3 of them. The first is as set out by the Court of Appeal in paragraph 60 of their judgment, which is MS 53, and the first of those is Rule 8.91 of the Jamaican CPR, and that states that the claimant must include in the claim form or in the particulars of claim a statement of all the facts on which the claimant relies. So, obviously, my highlight in relation to this, all the facts which a claimant relies upon must be included in the claim form or the particulars of claim. That's the first of the CPR rules. Secondly, as the Court of Appeal set out in paragraph 60 of their judgment at MS 53, Rule 8.93 states that the claim form or the particulars of claim must identify or annex a copy of any document which the claimant considers necessary to his or her case. That's the second of the CPRs. The third, as the Court of Appeal set out in paragraph 61, again at MS 53, of their judgment is Rule 8.9a of the Jamaican CPR, and that is that the claimant may not rely on any allegation or factual argument which is not set out in the particulars of claim, but which could have been set out there unless the court gives permission. So those are the 3 CPR rules. A further point to make in relation to that is that in Jamaica, that appears to have been extended so that a claimant may also rely upon any allegation or factual argument contained in any reply by a claimant. You get that from paragraph 61 of the Court of Appeal's judgment. Now, what that comes down to is that in paragraph 62 to 65 of the Court of Appeal judgment, the Court of Appeal went on to set out that statements of case, which, and they set out statements and cases which emphasise the importance of pleadings and the fact that they are required to mark out the parameters of the case of each party and identify the issues in dispute. And we rely, obviously, on all of those. And then in paragraph 66 of the judgment, which is MS 55, the Court of Appeal said that the effect of the Jamaican CPR and the cases that they referred to was that, firstly, any claimant must include in the claim form particulars of claim or reply, statements of all facts on which he or she intends to rely. Secondly, a claimant must annex or identify documents in the claim form, particulars of claim or reply, which it considered necessary for the case. And thirdly, a claimant is precluded from relying on any allegation or factual argument not set out in the particulars of claim or reply, but which could have been set out there. Now, we say that those are the rules, and we say that the Court of Appeal correctly summarised them. So that brings me to the facts of the case. Now, obviously,
Are you going to show us the summary judgment rules? No, I'm just going to... I've got a question for you about them or not. Yes, they are.
In the paragraphs in the Court of Appeal's judgment.
Yes, I just have a question about them if you finish with your section.
Yes, of course, my lord, yes.
If a party makes a claim based upon pleaded facts and applies for summary judgment, and the other party either pleads or deploys in evidence facts, different facts, by way of denying the claimant's facts, but those facts would also entitle the claimant to the relief sought, is the court debarred from giving summary judgment merely because there are issues as to which of the sets of facts is right, which couldn't be sorted out before a trial?
Well, Lord, I think your lordship knows the answer I obviously give is the answer which the Court of Appeal took to that, which is the Court of Appeal would say that you couldn't do that and that you can only rely on the facts which you, in fact, have pleaded. Yeah, that may or may not be right or wrong, but that is certainly what the Court of Appeal, the view that the Court of Appeal took in this case.
And you ask us to follow that?
I do.
Yes, I see.
Now, the next point, my lords, is relates to the facts. The Court of Appeal judges undoubtedly formed the view that it was evident from paragraphs 3 to 7 of the particulars of claim that the bank based its claim on the 27th of July promissory note and only on the 27th of July promissory note. My lords, you get that from paragraph 67 at MS 56, and you also get it from the second sentence of paragraph 71 at MS 59. And the respondent to this appeal says that the Court of Appeal was right to form that view, and we have set out in our statement of case a series of things which, if you don't mind, I'm going to take you through individually, because this obviously is quite important.
Yes.
The first is, my lord, paragraph 3 of the particulars of claim, which is at MS 99. And that paragraph, we say, expressly refers to and relies upon the 27th of July 2007 promissory note and its terms. And it explains that by the promissory note dated the 27th of July 2007, the respondent promised to pay Jamaican dollars 21,760,000 and interest. And then towards the end of that paragraph, all of that is defined as the demand loan. The second point is this. In the last sentence of paragraph 2 of the particulars of claim, the bank said that a copy of the promissory note, by which the bank meant a copy of the promissory note dated the 27th of July 2007, was attached to the particulars of claim.
I think you mean paragraph 3. Yes.
I'm so sorry, my lord.
It's all right. It's there.
Yes, I do. I do, my lord. I'm sorry.
I think that's the worst.
I just want to make sure I was looking at the right document.
Sorry?
We
Yes.
needn't worry too much. Yes.
And we say, obviously, that the reason that was attached was because it was necessary to the case which was being advanced by the bank. The third point is, of course, that the promissory note, as you can see from MS 103 to 104, was indeed attached to the particulars of claim, we would say, as being a document that's necessary to its case. The fourth point, if you go back, is to MS 102. You can confirm that this is the case, because what's stated on the front, on the page at the front, is that this is a copy of the promissory note attached to the particulars claim pursuant to Part 8.93 of the Supreme Court of Jamaica Civil Procedure Rules. So we would say because the bank considered that necessary to its case. The fifth point is that paragraph 4 of the particulars of claim also expressly refers to and relies upon the 27th of July 2007 promissory note and its terms. Now, you then have paragraphs 5 to 7, and we say that those paragraphs simply follow on from paragraphs 3 and 4. We say there is no other loan agreement referred to therein, nor is there said, we say, to be any other basis for the claim apart from the promissory note. And indeed, in both paragraphs 5 and 6, you see reference to the demand loan, which of course takes you straight back to the definition in paragraph 3, which itself began with a promissory note dated the 27th of July 2007. So we say that the only thing referred to in paragraphs 3 to 7 is the claim based on the 27th of July 2007 promissory note. The seventh point is that in the reply, the bank, this is at MS 117, the bank then itself makes it unequivocal that the 27th of July promissory note is being relied upon by the bank as a bill of exchange and not merely as evidence of the debt. For in the last sentence, the bank says it will rely on the Bills of Exchange Act.
In what respect is it relying on, or can it rely on the Bills of Exchange Act?
Well, my Lord, I don't know the answer to that question because it's not my pleading.
Yeah.
No, but
I think the answer may be
Yes,
they
but-
can't rely on it.
Sorry, my Lord?
Yeah, I think the answer that you may wish to give is that they can't rely on the...
no.
Well, certainly.
Your answer
If
is
it
whether
were-
they can
if
or
it-
not, they're trying.
If it
My
were,
Lord, they're certainly seeking to do so.
I accept that about their pleading, but my question is different. If it were a valid promissory note, in what respect could they rely on it?
If it were,
Valid.
Yes.
my Lord, you mean so that there was no forgery or anything like that?
Yes.
Well, in those circumstances, it would seem that the bank could rely on.
To what effect?
Well,
Would it neutralise the fact that there have been repayments of principal?
my Lord, I don't know the answer to that question, I'm afraid.
Well, it may be quite important.
Yes.
Well, I think my Lord's provisional view is it wouldn't, because if your indebtedness has been reduced between the time
You would
of
not-
the making the promissory note and the time that the money was reclaimed, the loan was reclaimed, the promissory note, at first sight, would hardly entitle the bank to recover the entire sum.
Well, my Lord, it would certainly seem inequitable if they were
Yeah,
entitled to recover the entire sum
Right.
if, say, half the sum had been paid off.
But the whole purpose of a promissory note is that the whole definition of it is that it is a sum certain in money, and if it is negotiated, then the holder in due course receives it free of any personal defence.
Yes.
But of course, we're not dealing with the holder in due course here. We are dealing with the relationship between the maker and the recipient of the promissory note.
Yes, my Lord, but we are not dealing with the holder in due course.
No, so-
We're only dealing with the original holder.
So I'm wondering, what does a reference to the Bill of Exchange Act bring to the party?
Well, my Lord, it may bring nothing, but it is there
And
as a reference
Yes.
to which I am able to tie the promissory note.
Yes, you can say it's a reference to whether it was effective. They thought they were pleading a bills of exchange case.
Exactly.
Yes.
That's the only point I was saying.
Does paragraph 5 of the particulars of claim give us any help at all as to whether they are claiming on a negotiable instrument for the total sum or on the underlying loan?
Right.
Well,
Because they seem to have given credit for payments made,
yes, they do seem to have given credit for
which
payments
is
made.
inconsistent, isn't it, with a claim on a negotiable instrument?
My Lord, looking at it that way, it is slightly inconsistent with it. But certainly, the one thing I think your Lordship and my Lady will have picked up is that certainly on our side, we had always understood that what was being run against us was a claim on the promissory note.
Well, you may be able to say that it seems to have been the view of at least some of the people on the other side as well.
My Lord, it has been the view of some of the people on the other side, and it also seems to have been the view of the Court of Appeal.
Well, Mr. Alexander,
Yes.
So,
you said, I think, earlier on that the claimant can also rely upon anything in the reply.
yes, my Lord, I did.
Would you look at paragraphs 4 and 5 of the reply, and you'll need to have open at the same time paragraphs 5 and 6 of the defence.
Yes, my Lord, I
Now,
think I have
the
both.
substance of paragraph 5 of the defence is to assert a borrowing of the money and making the precise amount of money alleged to have been borrowed and the making of some payments thereon. And that is admitted in paragraph 4 of the reply. So there appears to be a plea and an admission that there was in fact a borrowing of the relevant sum, the 21,760,000 and some payments thereon. And there's also on the face of it a full admission of the 2 mortgages, which, if one goes to them, recite the borrowing as well.
Yes, my Lord.
Why can't those be relied upon by way of part of the bank's pleaded case at summary judgment, i.e. relying on the fact that there was an underlying loan, the money was lent and only partly repaid, and indeed lent on the terms set out in the mortgages?
My Lord, that is certainly not the way in which we understood.
No, but I mean, I'm just taking you at your word and
is.
saying, well, let's look at what the reply says if the rules permit you to do so.
Yes, and certainly, I don't think this particular point, with respect to my Lord, obviously was made at the relevant time.
No.
My Lord,
Well, the judge obviously had it in mind that the loan had been admitted.
Well, my Lord, the judge had it in mind undoubtedly that the respondent accepted that she had received
The money.
and
not repaid it.
And also not repaid it.
Yeah. And that comes out of the reply, doesn't it, as being common ground?
Yes, my Lord, that is right.
Yeah.
But it also brings in the mortgages, and at page 225 you've got the first provision in the mortgage, which is a covenant to repay on demand. Actually, a lot of different sums, but including this one.
Yeah.
Yes, my lady.
Well, it's a standard personal covenant, which you'd expect, isn't it?
You would expect to see that there, yes. If I could go back to my list, there's not that much further to go in the list. The next one is obviously that there is correspondence between the parties' representatives, which references the bank's claim as being one based on the promissory note. Now, I'm not going to take you to those individually. What I can say is that paragraph 5F of our case is what we're referring to there. And in the footnote there, it gives you a footnote of MS 235 to 250. Please don't look at all of the pages. Well, please look at as many pages as you like, but the pages the pages that actually are specifically referred to are those at MS 235, MS 237, and MS 239.
5, 7, and 9.
235, 237, and 239.
Thank you very much.
Now, then, the next thing I'd like to refer you to is at MS 270, which is, I think, in volume 2 and that is the submissions prepared by the bank for the purposes of the hearing before the judge. And the points that I would like to make in relation to that are that the promissory note and the whole concept of promissory notes was referred to extensively in the bank's submissions. If I can just give you some paragraph numbers, paragraph 5 at MS 270, paragraph 12 at MS 272, paragraph 13 at MS 272, paragraph 14 at MS 272, paragraph 15 at MS 272, paragraph 16 at MS 273, paragraph 17 at MS 273. And indeed, it is actually said in paragraph 16 that a promissory note is payable on demand. And then, at the third sentence of paragraph 16, we get the bank has made demand on the promissory note. And thirdly, we get nothing precludes the bank from exercising its right to recover the sum due on the promissory note, and that's at paragraph 17 as well.
The trouble is they're not seeking to recover the sum due on the promissory note.
Well,
they're giving full credit for the sums that have been paid.
Well,
so, I mean, it may be that the bank has presented the case in a way that's adverse to them, because you say it's giving you a defence that you mightn't otherwise have.
Well, the way I think certainly we saw it worked is that everybody in this case was working on the basis that there was one claim. That claim was a claim on the promissory note of the 27th of July 2007. To that claim, obviously, once it became apparent that the promissory note in question was a forgery, one would think, for the purposes of summary judgment, that the defendant-respondent has, at the minimum, the right to go to trial to test that particular point.
Yes.
I don't mean this pejoratively at all, but essentially yours is a pleading case, isn't it? I mean, your point is, and it may be an entirely good one, the bank has chosen to nail its colours to the mast of the promissory note, and therefore it's fixed with that case. And if there are triable issues in relation to the validity of the promissory note, irrespective of the circumstance that the bank, had it cast its case in an entirely different way, might have not have any difficulty. The situation is as it is.
My Lord, yes. I mean, what you've got is you've got a situation where everybody is proceeding on the basis that we've got this the promissory note point.
Yeah.
Thus, the respondent to this appeal obviously can only plead a limited number of defences. Forgery, duress, that sort of thing, in terms of the promissory note.
Yeah.
And that obviously means that if she can't plead any of those, that gets you to judgment very, very quickly. And you can avoid any other types of arguments or set-offs or anything like that. So you can just go on the promissory note and there's virtually no real defence to it. So what happens in this case is that the respondent does plead to that. What the respondent doesn't do is plead to a separate debt-type claim. Because the understanding on the basis of these pleadings and on the basis of the other materials was that the only claim that was being run against her was the claim on the forged promissory note. Now, if that would get you home to an Order 14 summary judgment, on a summary judgment application, one would have thought that would always get you home if you've got at least an arguable case that there's a forgery. Turning to the other side of the equation, what of course then happens is you have a situation where the bank don't amend. Right? The bank always could amend to put in a debt claim and say, we are suing you as a debt claim. Now, I should actually tell you, the bank has now amended. Right? The document's not in the bundles before you, but the bank, immediately after the Court of Appeal decision, amended its claim to run as the primary claim a debt claim, and then to say that the promissory note was evidence of the debt claim. So the whole case has changed, and we've obviously had to plead to that in the interim. And we obviously say that we've got a variety of defences.
You say obviously.
Well,
you may or may not have, but it's not obvious from what we've got.
my Lord, can I come to the defences in a moment?
Yes.
I will. I mean, I'll give you a very brief summary of where we are in relation to that. But one that one ought to bear in mind is that obviously the Court of Appeal gave judgment, I think, at the beginning of August, or beginning of July 2016. The amendment was made in August 2016, and the first defence that we've got in those circumstances is a limitation defence. But I'll come back to that and the other defences as one would have been able to advance them if this had been thought to be a case about anything other than a promissory note.
Right.
What happened in those circumstances is we say that all the materials which I've shown you this morning were wholly supportive of the conclusion that the Court of Appeal reached, namely that at the time when the matter was before the judge, and at the time when the matter was before the Court of Appeal, the bank based its claim, and only based its claim, on the 27th of July promissory note, in response to which the respondent raised fraud as a defence. Now that's the first point. The second point is that we make is that there is no doubt that the bank did not refer in its pleadings to either the letter of commitment or the undated promissory note. And we can say that's incontrovertible because it's simply not there. Now, against that background, the Court of Appeal came to the conclusion that since the bank hadn't referred to either the letter of commitment, which incidentally in the amended pleading it does, and that's the primary way in which it puts the case, or relied on its contents in its particulars of claim and reply, and indeed that no amendment was applied for so as to refer to them, the judge shouldn't have placed reliance on those documents or any other documents other than the 27th of July promissory note or the instruments of mortgage. And we say that for four reasons. We say the bank's claim was fairly and squarely based on the 27th of July promissory note. That's the first point. The second point we say is that the bank could not rely upon the letter of commitment or the 20th of July promissory note because it had pleaded neither. Now, I just add to that, which of course meant that the respondent had had no opportunity to advance any defences to the claim based on them.
But in fact, both documents were put before the court by your client.
That's correct, my lord, yes. That is correct.
To vouch the fact that she had in fact borrowed that sum of money as she pleaded and as the bank admitted.
My lord, I think they were put before the court to demonstrate that the 27th of July promissory note was a forgery. It was in that context. So you therefore had two different promissory notes, one undated, but I believe signed on the 20th of July, and the letter of commitment at the same time witnessed in front of a different bank manager to the 27th of July promissory note, which was witnessed in front of a second bank manager whom... Allegedly, yes. Allegedly, yes. Now, well, the third point is this. The bank could have sought to rely on the other documents if it had wished to do so by way of seeking an amendment. But the bank chose not to do that. And if the bank had sought the amendment, then we would have been in a position to be able to run the defences to the debt claim that we didn't include in our defence when it was always thought to be a claim on a promissory note. And, my lord, we say that in those circumstances, it was wrong and unfair of the judge to create a different legal basis for the claim by the bank when we say that no such pleaded basis had been advanced by the bank. And even more wrong, we say, for the judge then simply to go on to give summary judgment on that unpleaded claim without ever giving us an opportunity to seek to put in a defence to the unpleaded claim. And as I will come on to in a moment, my Lord Briggs picked up about the amounts here. To give summary judgment, we say, in respect of sums that were not even claimed or sought in the summary judgment application.
If the only additional amount, but leave aside the fees,
yes.
If the only additional amount is onward accruing of interest at the date specified in the particulars of claim, why is that not sought in the particulars of claim?
My Lord, it is sought in the particulars of claim. It's not sought in the summary judgment application.
But there was a supplemental affidavit put in by Mr. Price for the summary judgment application which vouched the other sum.
I mean,
Yes.
If your claim is for a sum plus interest at a daily rate, and it takes, say, 9 months to get to summary judgment, are you saying the judge can't award the additional amount that's accrued until the hearing, between the date of the application and the date of the hearing, simply because it's not in the date in the application?
Well, there is a rule, which I'll come to, which says that.
It doesn't stop the court quantifying if in the application it's based on a claim that the money is accruing at a daily rate and the rate hasn't changed.
I mean, my Lord, there is a rule that says that you can't be given judgment in respect of something you haven't actually asked for in the summary judgment application.
But if you asked for and interest at a daily rate...
But it doesn't say that in the summary judgment application.
I see, okay.
Well, Lord, I'll come back to that in a minute, if I may. I think really what it comes down to from our perspective is this. The system we have, the system in Jamaica is as here. It's an adversarial system. A party makes such claim as it likes, and the defendant responds to the claim, not all claims that could be made against a defendant. And then we would say the court adjudicates on the issues on the pleadings, and it's not for the court to enhance the claim by effectively treating an additional cause of action as being in the pleading, still less to do so without there being an amendment and without giving us an opportunity to meet the amended claim. Now, I said that I'd mention the question of what defences might we have run in those circumstances. I mean, obviously, that would depend on what is actually pleaded against us, because we are pleading to whatever is put up against us. But, and we get some help from this from the Court of Appeal. The defences that would have been run obviously would have included those defences which the Court of Appeal in paragraphs 75 to 77 indicated might impact on the bank's prospects of success. That's MS62 to MS63. So, taking them all, obviously the first one they refer to at paragraph 75 is reliance placed on the 27th of July promissory note, and that we would have said was a forgery. The Court of Appeal then said in paragraph...
That was a defence.
That wouldn't have been a defence to a properly pleaded claim for the debt.
No, I'm talking about the whole claim.
Yes, but what we're after is what you've been lulled into a false sense of security and not pleaded.
My Lord, I quite understand exactly...
At least I think that's what we're after.
Yeah, no, this is exactly what you're after. I was just going, because if you look at paragraph 75 to 77, what the Court of Appeal do is they take it as if there had been both the claim that we thought was being run on the promissory note and a debt claim. And at paragraph 75, paragraph 76 at MS62, they refer to the fact that defence would have included the fact that no single document encompassed the terms and conditions of the loan, and the covenant to pay was contained in the forged promissory note only, and in any event that the letter of commitment and the mortgage instruments were all tainted by the fraudulent promissory note.
Why was it only in the forged promissory note? It was in clause 1 of the mortgage.
Yeah.
My lady, you're absolutely right. It is in clause 1 of the mortgage.
And the mortgage has been pleaded.
I'm not sure it is in the letter of commitment. Well,
All right.
But
So you have to rely on an argument of taint.
I have to rely on an argument of taint, my lady. That's the first point.
Yes, I see.
But how would the prior letter of commitment be tainted by a subsequent forgery?
Well, my lord, I think the way one would have to put this is that all of these documents are part and parcel of the same transaction, and that if the promissory note is tainted by forgery, then the whole thing is tainted by forgery. I think that's the way.
Yes, I can see that. But the problem, from your point of view, is that there's another promissory note which you agree you did sign in exactly the same terms.
And you admit that, and you admit the debt, you
Well,
admit the loan.
My lord, as I think the Court of Appeal go on to deal with, they do actually refer to the 20th of July promissory note, and I think that you get at paragraph 77, on the basis that it was incomplete and no money had in fact been issued to her under it. Indeed, the bank didn't even have it, because what you'll recall is that it's the respondent who produces the 20th of July promissory note, and the bank are unable, in fact, to even produce that.
Well, but once they've got it, which your client kindly gave it to them during the proceedings, but why does the fact they didn't have it at an earlier stage matter?
My lord, because no money was advanced to the respondent by reference to the 20th of July or undated promissory note.
I can see that would give you, at least I think I can, that might give you a defence if the bank's claim were treated as being made upon a bill of exchange, namely the 20th of July promissory note.
Exactly.
But that's not the potential claim which we're examining, is it? What we're interested in is whether there's a defence to a simple claim for the debt, which on the face of it you admit you owe.
Well, my lord, I'm not sure one would go so far as to admit one owes.
Okay.
We would accept
you admit you borrowed.
Yes.
Admit you
My lord,
borrowed,
absolutely.
you haven't repaid,
That's
yes.
totally fair. That's totally fair.
Yeah.
But obviously, we only owe it if we don't have a defence. Is the only point I'm.
Yes, but how does this incomplete promissory note work? And you say no sum was issued under it. The promissory note is dated 20th of July. It's for the sum of $21.76 million, and it follows on the commitment letter. So, I mean, quite clearly, it's referable to the same transaction as the commitment letter.
Well, save for the fact, my lord, that the bank did not actually produce any money in relation to this promissory note. They didn't even have it. They only got it subsequent to the proceedings starting in this case.
Well, they must have had it at some stage, because it was sent to your client signed it, sent it to the bank then signed it and faxed it back to your client, because the document that you're founding on, as I understand it, the defendant's promissory note, is on two sides of paper. The first side has Mrs. Taylor-Wright signing it, and the second side also has the signature of Wilton Smith. So the bank had it at some stage.
Well, my lord, yes, but we have to say that there is no evidence that the bank actually provided us with any money based on this particular promissory note.
Can you help me on one or two of the other defences being canvassed by the Court of Appeal? No single document encompassed the terms and conditions of the loan. Is that some regulatory defence that a loan of any kind is unenforceable in Jamaica unless the whole terms are in a single document? No? Okay, thank you. And I think you mentioned, didn't you, something to do with limitation?
Yes.
I did.
I'm just trying to understand how that works. As I record the particulars of claim, the last acknowledgement was on the 31st of December 2009 by a part payment. Where do we go from there so far as limitation is concerned?
Well, my lord, there's a letter of demand in, I think, March 2010, I think the 23rd of March 2010.
Right.
The amendment to the pleading that has been made was not made until August 2016.
But what about the admission of the loan in the reply, in the defence? What was the date of the defence?
April 2011, I think, page 116.
Yeah, it's
6 years is the limitation.
And there's omission of the loan both because of the plea of the mortgage and the actual omission of the loan.
But also there's the amended defence at MS 184, which has the admission of the loan at MS 181, and that's dated 18th May 2012. So what's the period of limitation?
Yeah.
well, I think the way in which it's been pleaded is by reference to the demand letter and not by reference to what's set out in the...
But can we take it that the Jamaican law of limitation in relation to things like acknowledgements and so forth is broadly speaking the same as
I believe
we're
it is.
familiar with in England?
And is it 6 years?
I believe it is, yes.
Yeah, thank you.
Um,
Anything else?
well, I mean...
There's an ex turpi causa defence.
There is an ex turpi causa defence, my Lord.
Interesting.
I mean, my Lord, I think all I can say in relation to this is that the Court of Appeal identified a series of defences which they said were not at the level where the defendant, the respondent, didn't have, if you like, a fanciful prospect of success.
Well, I think you can say that, however, how shall I put it, imaginative these defences might appear, you're entitled to say, well, unless they can be extinguished entirely, we're entitled to a trial of them.
Well, particularly in circumstances where you already have a promissory note which we know has been forged. In those circumstances, well, I say we know.
There's a prima facie.
There's a prima facie case.
You make a serious allegation.
There's a serious allegation, and it's supported by a handwriting expert who said this was not the respondent's signature, so the bank has actually produced this. Now, in those circumstances, I think we go so far as to say we ought to have a little latitude in terms of being able to explore the defences that we are actually able to bring in relation to this.
How does ex turpi causa just as a sketch work?
Well,
it's based on the forgery, presumably.
I think, my Lord, it has to be based on the forgery. I have nothing else but to base it on the forgery, yes.
And Mr. Bramham seems to have been submitting at some stage that the bank would have to rely on the forged document in order to succeed, which takes us back to where we started.
Yeah.
Well,
No, but I think we've moved away from Tinsley and Milligan reliance in this field. But the point remains. I mean, the causa that is being relied on is an admitted debt.
Yeah.
well,
So, and there is no doubt that on that causa, oratur actio.
Well, you've been shipping a lot of fire, Mr. Alexander, so perhaps we ought to let you...
look, all I can say in relation to this is that the Court of Appeal obviously went into the potential defences perhaps in a little more detail than one would today, and we have a situation where, you know, when we get here, there is no challenge to that part of what the Court of Appeal said. There's no ground of appeal to say that the Court of Appeal were wrong to come to that conclusion. There are lots of other challenges, but they certainly did not say that these particular points were wrongly decided by the Court of Appeal.
Right.
What I can also say to that is this, and that's because, as I mentioned, there is an amended pleading. There are a series of additional points which have been taken in the amended pleading, which follow on from the bank's amendment. For example, as I've mentioned, the claim is made after the end of the applicable limitation period. Secondly, that the letter of commitment, even if untainted by illegality, only amounted to a preliminary agreement. It did not contain a covenant to pay, nor was it complete, in that it depended for its completeness on the inclusion of additional terms and conditions so as to satisfy the requirements of certainty and consensus ad idem. Next, that the bank is unable to obtain any remedy because the illegality attaching to the promissory note means that no cause of action survives. Next, that the amount alleged to be owing can be satisfied from the mortgages, and that the bank sought to obtain an unfair advantage by forging the promissory note. Next, that the bank's forgery and consequent intentional dishonesty with intent to defraud the respondent means that she bears no liability to the bank. And finally, that the bank's forgery and persistence in reliance on that forgery amount to effectively a perversion of the course and administration of justice, such that the bank should not be allowed to continue with its claim. Now, I mentioned those are all in there. They're not in the documentation you have before you, but in addition to those points which the Court of Appeal already dealt with, those are points which the respondent will wish to explore at trial if it's allowed to do so.
Which of any of these points were deployed before the judge at first instance?
No.
Because the judge was faced, on, as I understand the facts, with a claim based on the promissory note, an assertion that that was a forgery, but the judge also had in front of him the commitment letter, the mortgages, the admissions in the defence, and the reply, and an assertion that the claim would stand up perfectly well even if there was a forgery on the basis that it was a loan that hadn't been repaid. And what I'm really asking is, well, was the judge told that at that stage you had your hands tied behind your back and there were a whole raft of other defences that could be run if that was the real case?
As your Lordship appreciates, I wasn't there.
No. Well,
would you mind
if you
if
want
I
to, please do.
just take instructions?
But I mean, the reason I'm asking you is this: it seems to me at least unarguable proposition that if the question whether there needs to be a trial of a case comes before a judge, and someone says, "Well, I admit I borrowed the money and haven't repaid it," it's really up to them to put on their cards on their table as to what other tribal issues might arise if that was the basis of the claim.
Well, I understand the point that your Lordship's making, but your Lordship will also understand
of course.
that the way in which this case proceeded, I think everybody was working on the basis that we're talking about a promissory note and not about this, and that the judge, I'm not sure, I'm going to check, but I think I'm going to be told that no, none of this was debated in front of the judge. Was that? I'm told that your Lordship will recall there was a strikeout application which was also before the judge.
Yes.
And I think in the context of that, some of these would have been explored. However, the judge ignored the strikeout application, didn't deal with it, and gave summary judgment.
Mm-hmm. Can you remind me where I have seen, but where we see the strikeout application? I have read it before. Is it 185? No. Yes, it's 185. The claimant has forfeited its right to proceed further in a claim in personam against the defendant.
Yes, my lord.
Grounds set out.
Abuse of process, ground 7. And forfeiting right, ground 8.
I'm sorry, my lord.
Yes, it's on 187. There's a claim for abuse of process and also a forfeiting of a right to have a claim in personam.
My lord, and as I understand it, neither of those were dealt with substantively. At that hearing, I'm told that the judge just dealt with the summary judgment application and simply left those to one side.
So it wasn't being, so it doesn't, so that the strikeout was never really deployed, is that right, before the judge?
Well, it was put before the judge.
It was.
But the judge didn't deal with it.
I see, okay.
The judge only dealt with the summary judgment application and not the... And I'm told he didn't even dismiss the strikeout application, he just didn't deal with it.
Did you say something about it, Mr. Alexander? I can't remember. I've seen somewhere somebody expressing a certain amount of puzzlement. Was that in the Court of Appeal?
About
the strikeout application?
I can't remember that.
No, don't worry. It either rings a bell or it doesn't.
Yeah, no, I'm sorry, my lord, I don't remember seeing someone expressing puzzlement about it.
Right, that's
In any event, your case, in a nutshell, is you were confronted with a pleaded case. You raised a triable issue, or several triable issues in relation to that pleaded case, and it wasn't incumbent on you to anticipate that the judge might move away from that pleaded case and find on a completely different basis.
Well, that's in a nutshell, yes. Your lordship has summarised what I've been trying to convey.
They did, at least before the judge, they did put it, didn't they? Top of page 12. First paragraph, which begins on page 12.
Is your lordship in the judgment?
Yes.
Oh, well, the judge's judgment is... I'm at 24.
Counsel for the claimant submits that this is really a claim for a loan and the promissory note is just evidence of it.
Yes.
So that at least seems to, they seem to have got round to that eventually.
Yes.
By the time they're in front of the judge, it's just, you're saying they never said that in any of the pleadings.
And not only did they not say it in the pleadings, but if one actually looks at the written submissions in advance,
yes,
it doesn't really come out of that either.
No.
So maybe it was said orally.
I wonder about that. Look at MS 166. This is the application for summary judgment. The issues the court should deal with at the hearing are the effect of the defendant's admission at paragraph 15, the effect of the defendant's admission at paragraph 5 that she borrowed the sum of money. So I mean, the matter was squarely put before the court in advance of the hearing that they were going to found on the admissions to the claim.
I mean, I understand the point that your lordship is making, but I think in the context of all of this, those could be interpreted as being that the claim is a claim made on the promissory note, and that's what we're really after.
Right.
Yes.
Would your lordship give me a moment? Yeah, I mean, my lord, can I just draw your attention to one other passage,
yes,
which is in Record of Proceedings, Volume 2, and this is the respondent here's submissions to the Supreme Court, so to the judge, and it's at MS 286. Paragraph 36, we would suggest, makes it pretty plain as to what the respondent thought was going on here, in saying that notwithstanding the fact the bank did not raise any other cause of action, it's the defendant's submission that if it did, the defendant would have had a defence to those causes of action as well, and the bank would not have done to summary judgment. It doesn't go into any detail, but does say, again, you can get a clear indication as to what the respondent thought was happening in relation to these proceedings.
And forgive me, what document is this? I've got the page.
My lord,
286.
that document is the submissions that were put in before the judge on my client's behalf.
Thank you. That's all I needed to know. I've got the page.
Would your lordship give me just
Yes, by all means.
Yes. Well, it does actually deal with all the other points. Not any of these.
Look, on that point, I have nothing further to say. I will obviously say something about bills of exchange if you want me to, but...
She does say, you see, against you, that even if it's an action on the bills of exchange, on the document as a bill of exchange, she's entitled to succeed, one, because you received value subsequent to the forgery, and two, because you are precluded from setting up the warrant of authority.
Yeah.
You may be able to deal with those quite shortly, but we better know what you say.
Yes, okay, I'll deal with that as quickly as I can. I mean, all of this, the Bills of Exchange Act, obviously, in Jamaica is obviously pretty similar to our English Bills of Exchange Act. It is not quite the same in that there are some occasions when a subsection 1 is applied to the first sentence and a subsection 2 in our Act, which doesn't actually appear in the Jamaican version. And indeed, there appears to be the odd random comma that sort of has got in somewhere. I don't know whether intentionally or not.
Well, apart from syntactical variations, not much to distinguish one from the other.
I mean, our position in relation to all of this is obviously it's not her signature on the bill, and she has not authorised her signature to be placed on the bill dated the 27th of July 2007. And if those facts are correct, something which we say can only be determined at trial and not on the summary process, then we say, prima facie, we can't be liable on the 27th of July promissory note. She didn't sign it, section 23. And there's one section which I don't think has actually got in, which I need to refer to, which is section 91. And what section 91 says...
You have a page number for us.
543. 543.
Thank you. Yeah, I've got it.
Does your Lordship have 91?
Yes, I do.
Yep. Is that any instrument, or where by this Act any instrument or writing is required to be signed by a person, it's not necessary that he should sign it with his own hand, but it's sufficient if the signature is written thereon by some other person by or under his authority. So what you get by reference to those two is that you can be liable if you sign it yourself or authorise someone else to do it. Now, we say that she didn't sign it, section 23, and indeed we say that section 91 doesn't help either. Is there a way in which you could make section 24, which is the one about preclusion of forgery or want of authority, apply to the facts of this case? Well, the bank says that because my client signed the promissory note dated the 20th of July, which I ought to add is not actually dated at all. It's just, it's for convenience. Everybody refers to it.
There's no date, but that was exactly when there was the exchange of faxes or whatever.
That is the time at which the letter of commitment was signed. I think at the same time. So what's put forward against us is that because she signed that one, she falls within section 24 of the Bills of Exchange Act because she's precluded from setting up the forgery or want of authority.
I don't understand that submission, because if you sign document A, why are you precluded from saying I didn't sign document B?
Or authorise someone about it.
Or authorise.
And, my Lord, I don't understand that submission either. All I'm going to say is, first of all, there's no authority for that proposition. Secondly, the mere fact that the respondent has signed one promissory note doesn't mean that she cannot say that a signature which purports to be hers on a completely different promissory note is a forgery. Nor does the fact that the respondent signed one promissory note mean that she gave the bank authority, if you like, to forge her signature twice on a completely different promissory note. We would then go on, and I think we've referred to this in the very short supplemental case that we put in attaching 4 cases, to say that the words precluded from setting up a forgery or want of authority are, we suggest, just not aimed at the circumstances of this case. What they're aimed at is a situation where a defendant is stopped from contending that his or her signature is a forgery, or where a defendant is stopped from saying that she did not authorise the person who placed her signature on the relevant bill to do so. Putting it another way, the words are aimed at situations where he or she has seen or knows of the bill and what purports to be his or her signature, and notwithstanding that, the person in question confirms effectively that, yes, I'm liable on that one. That's what that's intended to cover. Furthermore, we also say that to get anywhere near this Section 24 exception being applicable, we'd suggest that the person who is said to be precluded from setting up the forgery or want of authority must have actual knowledge of the forgery or want of authority. And there's no suggestion in this case that the respondent knew that the 27th of July promissory note bearing the forged signature twice even existed at any time prior to when it was attached to the particulars of claim. So we say Section 24 is just of no application here, and in those circumstances it wasn't misconstrued by the Court of Appeal. That really leaves Section 30, and we say that Section 30 is of no relevance or application here. It is merely a section dealing with the burden of proof. It doesn't correct or assist in correcting what was originally a forgery. If one looks at Section 30, I mean, obviously, it goes without saying, I think some reliance is placed on, this is at MS 511.
Yeah.
The first sentence says, every party whose signature appears on a bill is prima facie deemed to have become a party thereto for value.
Yeah.
All very good, except for the fact if it's not your signature, that sentence just doesn't help you.
So do you read Section 30 as being the section which, if anything, is contemplated by the submission that receipt of value subsequent to the forgery in some way validates the forgery?
Of the sections which are referred to, I think this looks as if it must be.
Right.
You then get every holder of a bill is prima facie deemed to be a holder in due course, and so forth. Now, the only problem with that one, with the second section, the second sentence of Section 30, is that it's previously been, I ought to explain, I mentioned a minute ago that you had, in the English Act, this is one of those occasions where the first sentence is marked Section 30, subsection 1, and the second sentence is marked Section 30, subsection 2. Now, we're dealing with Section 30, subsection 2, if you like, of the English Act, so the second sentence, and that does not actually apply in a case in which the holder who is seeking to enforce a negotiable instrument, i.e., in this case, the bank, is the person to whom the instrument was originally delivered and in whose possession it remains.
Can you be a holder in due course of the instrument that you yourself originally entered into?
I don't think so, my lord.
Yeah.
Yeah, I mean,
It's a subsequent holder, isn't it?
Exactly.
Yeah.
yes, it's the endorsee. There's in the bill of exchange, it's the drawer orders the drawee to pay the payee, as I understand it. And if the drawee accepts, the drawee becomes the acceptor. And the initial person who holds the bill, the payee, can then endorse it to a third party. And if that third party acts in good faith and for value, he's presumed to be a holder in due course under Section 30, as I understand it.
That's how I understand it.
Yeah, well, the definition of a holder in due course is in 29.
Yes.
It is in 29.
Set out quite helpfully.
And actually, all of this is quite helpfully dealt with in two cases. One called Talbot and von Boris, which is referred to in paragraph 2.2, subsection 2.2 of our case, in the supplemental case, and then also the Jones and RE Limited v. Waring and Gillow. I mean, I won't take you to them because what they do basically say is that the original holder doesn't fall within this section. does your Lordship have any further questions about that?
It was only the 2 points which were being raised against you on the basis that it was an action on the promissory note, which I just wanted to be clear about.
I hope I've dealt with
You
it.
have, thank you very much.
My Lord, so, well, your Lordships and my lady have our position in relation to this. Obviously, we rely on everything that's in our written cases, and we would ask that you dismiss the application.
Thank you very much indeed, Mr. Alexander. That's very clear, if I may say so. And thank you for dealing so promptly with our questions. Mr. Wright. Thank you very much. Mrs. Minot-Phillips, please.
Please, my lords. First of all, I'd like to advert your Lordship's attention to page 96, MS 96.
96.
And you'll see, first of all, that there is no reference at all to the promissory note in the claim form, which in Jamaica is considered a part of the pleadings. And what the claim form is saying is that this is an action for recovery of unpaid balances on credit facilities extended to the defendant by the bank.
It's paragraph 2, is it?
Yes, extended credit facilities.
Yes.
So the reference to the promissory note was only by way of it being evidence of the original disbursement. It was not meant to be more than that.
Anyway, you're relying on CPR 8.91, which speaks of of including in either the claim form or the particulars of claim all facts relied on. Is that the point?
Well, no, the point, well, there's that, but there's also the fact that my Lord Briggs mentioned, that in summary judgment proceedings, the judge is perfectly entitled to rely on all the pleadings that are before him. He's not confined to the particulars of claim and the reply. It's not a striking out application. It is a summary judgment application. And in that sense, Jamaica is no different from here. The judge is required to look at all the material before him, including the pleadings, including the affidavit evidence, and anything else that comes in by way of evidence. Now, ordinarily, if the matter was going to trial, the opinion evidence of the forensic, of the handwriting expert would not be admissible until the court orders that it needs the assistance of an expert witness. But I'm not taking that point because we're in the realm of summary judgment.
Yeah.
So I'm saying let the court look at everything, including that. So it is correct that what the bank was, so the learned judge at first instance, Honorable Mr. Justice Sykes, was correct in finding that the bank could establish its claim for money, for money dispersed to Mrs. Taylor-Wright that she has admitted not repaying, without reliance on the promissory note, based on her admissions and so on. And as your Lordships correctly pointed out and noticed, the actual summary judgment application sets out in it the issues on which the summary judgment is being sought, namely her admissions and so on. Now, the learned judge below was also correct in finding that all the essential loan terms were contained in the commitment letter, which she says she signed on the 20th of July, 2007. Furthermore, there could be no limitation defense in this matter. Let me just put that to bed right away, because if you look at the statement of account that is exhibited by the bank in support of its application, one of the exhibits, you will see that the last payment made on the debt was made in December of 2009. And the claim was filed in 2011, a mere 2 years subsequently.
No, you missed the point. The limitation defence is advanced in the event that you'd succeed in, to the extent that you have raised a new claim in 2016.
But we have not raised a new claim.
Well, that's the whole point, isn't it?
Yes, but even if you were to fail here and had to fall back on your application to amend in Jamaica, you would rely, I assume, on the date of the amended defence, where the defendant repeats her admission of the fact that she'd borrowed that sum.
And therefore time runs from the date of the admission.
Yes.
So there's no limitation point to be taken. But in any event, she was not precluded from taking in her defense any point that she could have advanced, limitation or anything else, to challenge the bank's claim to recovery of the debt. She could have taken it then. She chose not to take it. And when you look at her affidavit evidence put before the court, you would see that that was a deliberate decision she took, because she chose to interpret the case on a narrow basis as being an action on a promissory note. When if you look at the claim form, you see it is not that. And if you look even at the particulars of claim, demand loan numbers.
If you succeed on that, you're home and dry.
Exactly.
If you don't, what she's saying is, I haven't got any reason to advance my defences because they're not defences to the claim as it is put. That's...
Well, I'm, of course, I'm hoping that we succeed on that.
Yeah.
But I'm more than just hoping. I'm submitting that we ought to succeed on that.
Yes.
Right.
Because if you even look at the language that is used, it speaks to demand loan number and gives a demand loan number. It is not a reference to the promissory note.
Okay.
And if, assuming that the bank would not have been able to act on the promissory note because there was part repayment and therefore the entire note, it could not have called upon, it could not have used the note to secure the entire amount stated in the note, because it was acknowledging in its claim that it had received payment from her of various sums on account up until a certain point in time. So it emphasizes the fact that the Honourable Mr. Justice Sykes at first instance was correct in disregarding the promissory note substantially.
Yeah.
He was correct, and he can't be faulted. And the short point is that if he can't be faulted, then there was no basis for the Court of Appeal. Whatever might have been the errors of counsel coming before him in terms of putting maybe over-pleading or under-pleading or whatever submission they may have advanced or not, the question is, was the judge correct? And the judge was certainly correct when he gave his decision at first instance in the way he did. And since this is a matter of his discretion, if it is that he was correct in so doing, there was no basis for the Court of Appeal to substitute their decision for his. And that's essentially the short point. I wanted to also mention, thank you, the strikeout application. Although he did not expressly deal with the strikeout application filed by Mrs. Taylor-Wright, you will see in the issues at page 186, if you look at the issues that are set out in that strikeout application, you will be able to identify, when you look at the judgment of Justice Sykes, that he has in fact in his judgment addressed all of those issues at item D, 1 through 8.
I'm so sorry, what page are you on?
MS 186.
MS 186.
186, thank you.
Issue 1 was removed because that was the credit card debt, so it was removed. There was nothing in relation to issue 1 by the time the summary judgment came on for hearing. And so when you read his judgment, you will see that the answer to issue 2 is yes, and that that in relation to whether the instructor in the proceedings by the defendant of an incomplete but genuine promissory note signed by her amounts to an admission of the claim. First of all, that promissory note was not incomplete. This is a heresy that is being perpetuated through the, but in fact, it was not incomplete. Interest was included in it. She says it was incomplete because there was no interest in it. Interest was included in it. And in fact, when you look at the documents that she put before the court, you will see that at the time that the fax was sent to her by, she says, on her evidence, Wilton South, that the interest was already included in it when she signed it and faxed the document back to him.
Well, so I think you were taking us through the reference to the application for summary judgment. That appears
striking out, yes.
Yeah.
So when you go through these applications, when you go through these issues, you will see in one way or another that the judge has in fact addressed them in giving his reasons in relation to the summary judgment application. And by the judge, I mean the Honorable Mr. Justice Sykes at first instance.
Yes.
There is one more thing I wish to clarify. If you look at page 1, you look at page 155, MS 155,
yes,
you will see that Mrs. Taylor-Wright says that the original of the promissory note she signed on May 20, 2007, and the original of the letter of commitment were returned to the bank and remain with the bank to date. That's her document. So it is not correct to say that the bank would not have known about or would not have seen this May 20. On her case, she returned those documents to the bank.
well, I don't think that's being said on behalf of the respondent. What I think the respondent says is that it wasn't until it was produced or reference to it was produced in the course of the proceedings that the promissory note of the 20th of July became an issue.
I prefer to
And
say
that the bank has never been able to produce it from its own.
Well, the bank's position always has been that it's 2 copies of the same promissory note.
Yeah.
2 copies of the same promissory note. And if you look at, and that is why this is it. That's what makes this an unusual case. And that is why it says she's precluded from asserting want of authority. Because if you look at the document on MS 156, which she admits that she signed, she is authorizing the issue of a promissory note in the amount, securing the amount of $21,760,000 at an interest rate of 19.5% to the bank, payable on demand. She by her own evidence is saying she authorizes the issue.
Yes, but that doesn't in any sense preclude her from saying, because I signed the document we're calling the 20th of July, I didn't sign the document on the 27th of July. It isn't my signature.
And we're
I mean, how can she be precluded from saying that?
Perilously close to the area where these are all matters which require to be tried. If it's going to be a matter, an issue.
Well, we don't think it's so much an issue because of the receipt of value subsequent anyway.
Right, right.
Can you just explain to me? I'm sorry, I'm a bit behind the pace on this bit of it, Mrs. Phillips. Where does the receipt of value subsequent to the forgery provide you with an answer to it, even if it's a forgery?
Well, the bank, if we were relying on the promissory note for the purpose of negotiating it, the bank would be considered to be if it was, we are not.
If you were relying on
Because
it
we
as
were-
a negotiable instrument.
As a negotiable instrument,
Right.
because what we are relying on it
If
was,
you were the holder, you mean?
the bank is the holder.
You're not the holder in due course, are you?
No, because the bank, it's only the name of the bank that has changed. The bank was the original holder and has been the holder.
Yes.
But Lord Fletcher Moulton, in his decision in Lloyd's Bank and Coke, which is referenced in one of the supplemental authorities handed up by my friend, observed that the Act did not intend to impair the position of a payee as contrasted with that of an endorsee, and that a payee who has given value in good faith is intended to come within its provisions as a whole in due course, just as much as an endorsee. So the point is not free from difficulty. But the fact is that the bank's intention in saying that it was relying on the promissory note was only to use it as evidence of the disbursement of the funds.
All right.
Nothing more than that. And that its general claim was for a claim for debt admitted, overdue, and unpaid.
Yes.
And its position was that there's no forgery, that both promissory notes are the same, and since she is saying that her evidence is that she authorized the issue of a promissory note to secure this debt, and the two promissory notes are referring to the same debt. It's not two different debts. It's the same $21,760,000. Since she says in her evidence she authorized the issue of a promissory note for it, surely the bank is saying she should
Who did she authorize a promissory note?
She issued a promissory note.
Well, what's authority got to do with it? I mean, in one case, she signs a document. In the other case, she says she didn't sign a document. How does authority come into it if there's no third-party signatory?
Because forgery is an alternative to want of authority. If you look at the section.
But why is she precluded?
So that if you have, sorry, Madam.
Why is she precluded from saying, I signed document A, but I didn't sign document B?
She can say it, but the question is, would it stand up? And since
Are you saying that by the 20th of July document, she authorised her signature to be applied by somebody else to the 27th?
I'm saying she authorized the issue of a promissory note, so it doesn't matter whether the signature was hers or whether it was placed there by somebody else, because she authorized the issue of a promissory note to cover that indebtedness.
But who did she authorize?
She authorized the bank. She issued the promissory note.
She issued it. I mean,
She issued
your
it, but she
case-
authorized nobody.
I mean, your case is simply that these supposedly two promissory notes are really just two copies of the same document.
Same note.
She signed one, she didn't sign the other, but the one she did sign is perfectly good for the purpose.
Yes, and
Yeah.
well, our case is that she signed both, but she's saying that she didn't sign one, but the one is good for both because it's the same debt.
Yeah.
It's two copies of the note for the same.
But if you didn't have either of them, it wouldn't matter to your claim.
It wouldn't matter because we could still establish the underlying.
Yeah, but that's a totally different argument from the preclusion of arguing forgery. I mean, your case is much simpler than that.
Yeah.
Your case is that she has signed a promissory note for that debt, even if, which you don't accept, the 27th July
not actually
promissory
signed by
note
her.
doesn't bear her signature.
Was not actually signed by her.
Because this isn't somebody claiming on the 27th of July document. The bank's on that footing got both of them. And
Bank
the fact
has
that one
both
is a
of them.
pure piece of waste paper with
bank has
forgery
both
in it
of them.
is neither here nor there. That's your case, as I understand it.
Yeah.
Right. Anything else?
Oh, and of course, there's nothing inherently illegal about a bank lending money to.
I'm sorry, say that again, please.
There's nothing inherently illegal about a bank lending money to someone. So in relation to the illegality point,
No.
Getting dangerously into territory where they should be tried. Well, thank you very much indeed. The board is very grateful to Council for the economical but nevertheless comprehensive, not to say thorough, presentation of issues in this interesting case. The board will take time to consider what advice they will humbly tender to Her Majesty. And the court is now adjourned.